ever-growing list of rules, the nuances that often catch us out. And I don't know about you, but when you sit in court and you have an argument and your opponent then suddenly says, "Ooh, the overriding objective," you then sit back and go, he really is scraping the bottom of the barrel. He's got nothing substantive to say. Wrong. There are recent appellate decisions that are now bringing back with enormous force proportionality within litigation across the whole, and parties are busy being punished if they do not comply. This is the first case, and I have to say, some of these cases are replete with silks involved. I'm busy scanning the room for Simon, who's left. And I want to give you some facts about this case before I start. The bundle was 6,000 pages. The skeleton arguments from both sides nearly ran to 160 pages, and the authorities before the court ran to tab 142, and themselves amounted to some close 3,600 pages. Ooh, I hear you cry, that's a lovely trial. That's for a 2-day interlocutory hearing before the High Court. It did not take Mr. Justice Andrew Barker long in his 132-page judgment, starting at paragraph 13, to launch into both parties with regards to this paperwork before him. He was critical of all involved, although rather strangely at the end he didn't make any adverse costs orders. Nonetheless, the parties were laid bare with how they had conducted this litigation. It was set, as I've set out in my handout, a claim for 20 million. Costs for 2 days hit 1 million. And the judge said this, and you forgive me as I read it out. Even in the context of claims of 20 million, what I have just summarized is disproportionate and unreasonable approach to proceedings, wasteful of the parties and the court's resources. It represents the kind of interlocutory battling that is readily explicable only by the failure to focus on what is sensibly required to do justice to any applications that might reasonably be pursued. It was unnecessary, said the judge, for matters to be dealt with so expensively, to the extent that serious points were raised and properly focused effort to tackle them, keeping a careful eye on the summary nature of any assessment and merits at this stage, and making sensible use, and here you go, of the guidance provided by the Commercial Court Guide, should have enabled them to deal with it much lesser cost. There are various guides which find their way into Volume 2 of the White Book, often not read, often disregarded. No more. They are there to be read and they are there to be complied with. The Commercial Court guidance at the moment makes no reference to adverse cost orders, should you not comply. However, for those of you that practice also where the Chancery Guide comes into force, the Chancery Guide says at paragraph 1.15 of the guide, the phrase, "Don't comply, adverse cost orders." The guides are there to be read, to focus how the parties need to conduct litigation. I've included in the handout in the pack before you, at paragraph 6, the brief intro to the Commercial Court Guide, which I needn't read out and I'll leave you to read it yourself. But within that guide, there are various appendices, and the big one, of course, is bundles at Appendices 7. In the Commercial Court, and for those of you who are a little bit unsure about the Commercial Court cases defined in paragraph or part 58.1 of the Civil Procedure Rules, no hard copies. It's all electronic now. That means that your admin assistants, bless them, need to know about bookmarking, hyperlinking, pagination, and OCRing. And the judges now are coming down on this very, very hard. The big one is pagination. Pagination in an electronic bundle should start at page 1, on page 1. That means if you have an index, that is page 1. Page 1 does not start 2 or 3 pages into the bundle. They are not impressed, I'm afraid. Small, I accept, but if you have a trial with 6,000 pages, you're going to want the pagination fairly easy to manage. So your bundling needs to be, I would suggest, relatively perfect. The guide also says, and I know a lot of you are going to go, oh God, yes, but my opponent's really difficult. The preparation of bundles, says the guide, requires a high level of cooperation between legal representatives for all parties. It is the duty of all legal representatives to cooperate on a high level. Therefore, you need to focus on what's in a bundle, not simply, I'm afraid, lump everything in. I had a case the other week whereby it was listed for an hour application and it was over 500 pages, of which I counted them, 459 were a waste of space. And the judge didn't read them. There needs to be some form of focus. Because with these cases coming out, it's only going to take an opponent to turn around and said, didn't need those, and say the immortal word, costs. That's coming. And again, just to reiterate, the guide then continues and says bundles should only contain documents and authorities that are necessary for the hearing. And the judge, certainly in Investbank, was critical of the bundles authorities, saying a lot of them were just down to propositions of law. You don't need cases just to establish propositions of law, more to the points that you are making. But as with the CPR, and as we are not in London, there is, would you believe, a circuit commercial court guide, which deals with all the nuances of cases that are not being dealt with in London, but runs alongside the commercial court guide itself. A lot of it just simply says, well, see the respective paragraph in the main guide. Others are slightly different. I'm not going to go into the differences because we would be here most of the day. But again, it's there to be read. And those that appear in the commercial matters, as I expect Jonathan has now told you with his reported cases in his speech, they're going to zero in on this. Why haven't you complied with various bits and pieces? The other aspect that the judges are now really complaining about is the length of the hearing and the estimation of what that is. And on the 22nd of May, there was a commercial court users group, and I said at paragraph 10, where Foxton J warned practitioners about being too unrealistic in giving time estimates for what's called heavy applications, and that's applications that are going to last for over half a day. And it should be properly considered. I would suggest, therefore, ladies and gentlemen, that if you are considering instructing counsel to represent the client at a hearing, that you seek his or her opinion as to the length of the hearing. There's no point filling in an application form and then flipping a coin and going, oh yeah, it might be half a day, it might be a day. And then throw it out to counsel and he says, well, actually, I've got a 160-page skeleton argument and it's going to be 4 days. Isn't going to please the court. And that's important that I would suggest you do that. Again, I've highlighted in my handout the aspects that the judge in the case raised with regards to the commercial court guide and authorities and quoting of those. So you can see, I appreciate that it is somewhat of a nuanced case, but I would argue that this will have a ripple effect through the specialist courts and how you deal with, there you go, hearings. I want to move on to another case, and this is Samsung. Again, it's relatively recent. I accept, before everybody starts leaping up and down, it was to deal with the guideline rates of London. solicitors. But the Court of Appeal have come out and said that if you want to claim more than the guideline rates, you are going to have to provide clear and compelling justification for doing so. That means in your cost schedule, if the guideline rate is, let's say, £250 and you're claiming £350, you're going to have to give the court or counsel information as to why you are claiming more. Courts are now really sticking to these guideline rates. It is unlikely, unless that justification is coming through, that you are going to achieve more than what is set out. Now, I raise this because I appreciate it's not done with London, and I appreciate it's to do with commercial aspect. But it doesn't take much of a stretch of imagination for you to sit in a probate matter or any other matter for the county court where you have a cost schedule that you're going to have to defend with the solicitor charging more than the guideline rate. It's just as simple as that. It's a simple argument just to reduce it. And also, I would suggest, if it is massively excessive, one has to question the statement of truth at the end of your N260 form. Because if you're not justifying it, that statement of truth, therefore, is somewhat otiose. Someone's going to raise it. Now, this is where I get very up to date, because it's neither in your handout nor on a slide. Why? Because it came out yesterday, and I'm afraid Mr. Walker wanted all the handouts in before this so he could print it off. So here you are, an up-to-date case, and the case is called Curtis with a C, Zurich Insurance, 2022, England Wales High Court, 1514, open bracket, TCC, Technology and Construction Court. I raise this because it's under the same principle that I mentioned with regards to certainly Investorbank, but on a completely different matter. Those of you that operate within the business and property courts are well aware of that lovely practice direction 57 and all the witness statements and how to write them and what they're required, and it's a complete nightmare. Well, in this case, one side decided to make an application to strike out 42 witness statements. They served a 109-page schedule saying why. The judge, unsurprisingly, was less than impressed. In fact, he went as far as saying that they lacked a common sense and proportionate view. This was the objector, and that the CPR was not there effectively for a stick to beat people with. You've got to look at it in a proportionate way. And he gave the example where, but if you have a part of a statement that you don't agree with, instead of applying for it to strike out, your counsel or you can just simply ignore it, cross-examine on something else, and then make your submissions. Does it really need to warrant an application to strike out? You've got to think about these things. So much was the judge annoyed that he gave the party applying to have it struck out costs of 75% of the other party on an indemnity basis. Ouch. Okay, and it brings back, I would suggest, the circle completes itself. The overriding objective that we raise our eyebrows with when raised, the issue of proportionality, is now coming more to the fore. Familiarity and the contempt that sometimes raises following the introduction of the civil procedure rules is no longer being tolerated. And there will be more cases such as this, and there will be arguments that if you haven't done this, if you haven't followed the guides, if you haven't looked at this in a proportionate way, you will simply be penalised through costs. It's as simple as that, ladies and gentlemen. The warning is therefore there, and I would suggest ignore it at your client's peril.